For more on the rearrest of Mr. Omoyele Sowore, we're joined by Frank Tietie, a lawyer and rights advocate from our Abuja studio. Mr. Tietie, what do you think about the arrest of anyone within the courtroom?
Well, by the way, thank you very much. It's unthinkable that this could ever happen in Nigeria, that we could descend to this level of barbarity, this level of uncivility, and while a lot of people are working to salvage the image of this country, some persons take delight, and especially persons who are supposed to be, who have understanding of the law, who are in law enforcement, take delight in rubbishing the image of this country, making a mockery of us, making a mockery of, our court system. It's unheard of. It's unthinkable that a law enforcement agents will go into a court, the presence of the court, whereas there are clear provisions in the Administration of Criminal Justice Act that when even anybody who is in any way restrained by handcuffs in one way or the other, the moment you enter into the court, that it symbolizes the liberty, and you have to remove those handcuffs. Now, to think that the DSS would, for no reason, decide to be this, criminally overzealous, in an attempt to destroy our legal system, I mean, it's most unfortunate. It's something that I'm unable to even contain, and I don't know how to describe it, but I don't know where this is coming from, and this has very, very, very grave implications. You cannot, as law enforcement, you cannot, as a government, be urging citizens to obey the law, and then you foist a system of lawlessness. You carry out a regime of disregard to court orders and desecration of the revered institution of the judiciary. This is unacceptable, and I hope that they do know that this process, this process of deprecating Nigeria, this process of reducing Nigeria to this level of barbarity, this level that shows us as a people that we are not civilized. We don't know how to organize ourselves. It goes beyond that, and it even has more security implications, because people will now begin to think that there is a lot more to this that meets the eye.
I do know that you're very passionate about this, but I asked a question earlier about what is required, for instance, for anyone to be arrested within a courtroom. Does it require a judge to give an order for that to happen?
No, it is not supposed to be. Arrests are not supposed to be made in the court, because a person who has already subjected himself before the authority, before the jurisdiction of that court, is at the direction of the court. Now, arrests are only necessary when a person is in the course of committing a crime, or a person has refused a summons. Now, in this case, this is someone who is standing trial, who has already been granted bail by the authority of the court. It is incomprehensible. It is unknown to our law. It is not even a matter of, something to be considered, that during the course of proceedings as reported, that law enforcement will disrupt. There is no reported order of court. There is no reported application to the court to restrain the person of Sowore. We are not even talking about the personality here. We are talking about, a situation where our courts have now, first and foremost, we've seen how much they can now ridicule our, orders that flow from Nigerian courts. But to not also disregard the authority of the court to the extent that you will deprive a citizen of his liberty within the presence of the court, unknown to Nigerian law, without any precedent, is something that goes beyond being worrisome.
The agency says there are fresh charges, as confirmed by Mr. Sowore's lawyer. What would have been, or what should have been, the right procedure to see that those charges are brought before the court?
Simple. Just go and amend the charges that are already before the court. You do not have to. You do not have to create this hula baloo, this drama, this sensational approach to things, thereby destroying the image of this country before the international community. We worked very hard. We keep working to defend the human rights situation in this country. And to now think that the DSS would deliberately make this kind of, blunder is something that I cannot imagine. So if you think that there are fresh charges, or they are fresh, just like Femi Falana has said, what could he have committed? What could he have committed? What offense could he have committed in the last 120 days that he's been in custody, sometimes mostly illegally? So all you need to do is 5 fresh charges, 5 fresh elements that support the offense before the court. And after all, it is the same court, and then his bail can also continue. But this is clearly a mishap, a very, very unfortunate, it's such an unfortunate mishap.
Thank you very much, Mr. Tietie, who's a lawyer and a rights advocate. Thank you for speaking with us.